This is from Bearing Arms, and I just thought I would put this up here. This kind of bugs me in a way. I want you to listen to what I got to say here. This was dated June 25th, 2019. Unconstitutionally vague. Gorsuch sides with liberals in striking down a federal gun law. Now, just by looking at that and listening to those words, it sounds pretty nifty for our side. But I'm going to go down here just a little bit more because I want you to understand something. Okay, he was, Neil Gorsuch was such first in the string of successful judicial nominations for the Trump White House. Not all of them have been smooth. Justice Kavanaugh was one of the most brutal in recent memories. Okay. Anyway, Justice Gorsuch sided with the liberal wing in striking out what he described as a vague gun law. But here's the part I don't like. It's one that Kavanaugh noted was essential in driving down violent crime. Now, wait a minute. If you're in the Supreme Court and you're looking at a law that's, unconstitutional, why are you worried about it? It's one that was noted for essential in driving down the violent crime. Okay, the long question calls for longer sentences when a person uses a firearm in connection with a crime of violence, so on and so forth. But even the government admitted the language provided no reliable way to determine which offense qualifies the crime of violence and thus is unconstitutionally vague. Okay. Vague laws leave it to unelected attorneys and judges to determine what acts as crime, when really it's Congress's job to make that decision. Anyway, here's the part I don't like. Fox added that Kavanaugh warned of the parade of horribles that this could bring, especially when it comes to prosecuting new gun laws. He also noted that thousands of violent criminals could be released sooner due to this ruling. He also noted that the court strikes down a 33-year-old law in this about-face on its own constitutionally, which is an extraordinary event. He said this is a serious mistake. He cited statistics on gun violence trying gun laws like the one challenged before the court as having contributed to the decline of violent crime in America. The decision to strike down the 33-year-old law often prosecuted federal criminal law because it's all of a sudden unconstitutionally vague and an extraordinary event in this court. It could lead to the early release of these convictions under the law and hold back Congress's law enforcement policy, destabilizing the criminal justice system and undermining safety in the American community. Oh my God. Here's the thing I'm worried about. I'll put a link in here. I want you guys to go read this yourself. Number one, what is Kavanaugh going to do when he finds out that all the federal gun laws that were ever passed are unconstitutional, being outside the scope of power granted to Congress through the enumerated powers? What will he do then? Is he going to follow the Constitution, or is he going to follow his own human whims? That really bugs me, people. The Constitution, it don't take a lawyer to figure this out. That the Second Amendment to the United States Constitution ratifies and preserves for every citizen the right to keep and bear arms, and neither Congress or any other instrument of the federal government, they cannot constitutionally infringe upon that right. They are constitutionally barred from passing firearm laws. Okay, we're going to go over here a minute. These are this is Article 1, Section 8. These are the powers that Congress has: to borrow money, to regulate commerce with foreign nations and among the several states and with the Indian tribes, to establish uniform rules of naturalization, to coin money, to provide for the punishment of counterfeiting, to establish post offices, to promote the progress of science, to constitute tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas. All right, to raise armies, to provide a navy, to make rules of government and regulations on land and sea and their forces, to provide organizing armies and discipline the militia, to exercise exclusive legislation in all cases over such not exceeding you. All right, now you've been there. All right, to make all laws which shall be necessary and proper for the carrying into the execution of the foregoing powers, and to all other powers vested in the Constitution and in the government of the United States or any department or office thereof. Now, let's go over here just a second. I went too far. Yeah. This is a necessary and proper clause. Article 1, Section 8, Paragraph 18 of the U.S. Constitution, which authorizes Congress to make all laws necessary and proper to carry out the enumerated powers of Congress. That means the ones that are listed. And all other powers vested in the government of the United States. These words are not limited to such measures which are absolute and indispensable and necessary, without which the powers granted must fall into execution, but they are included the appropriate means which are conductive or adapted to the ends of the accomplishment in which the judgment of the Congress will want to advantages of effect, so on and so forth. But I want you to see this. The necessary and proper clause of the federal Constitution is not a grant of power, but a declaration that Congress possesses all of the above necessary means and proper to exercise everything that they need and to carry out its specifically granted powers. That means the enumerated powers. They can only use those enumerated powers. And what am I getting at here? They do not have the power. It's beyond the scope of their power to pass any gun laws. It's not in their. That's not in their vocabulary. I don't care what they say. Commerce Clause was written only, putting in there for a reason to stop the states from adding taxes and tariffs to the goods flowing through their state. You find out that the Second Amendment to the Federal Constitution recognizes that we have a God-given right to keep and bear arms, and it's to be free from any interference whatsoever from the federal government. Also, according to the federal government, nowhere in the Constitution is granted authority to abridge, restrict, or infringe in any fashion whatsoever guns or ammunition. All restrictive laws made by Congress and regulations made by the Bureau of Alcohol, Tobacco, and Firearms are unconstitutional as being outside the scope of powers granted to Congress and to the executive branch by our Constitution. Restrictions of arms and ammunition is not one of the enumerated powers delegated to Congress or to the executive branch. Told you before, if you look at the Second Amendment, excuse me, I got a frog in my throat. Oh, jeez. Just remember, a well-regulated militia being necessary to the security of a free state. The right, remember, the right of the people to keep and bear arms shall not be infringed. Now, after the word infringe, there is no subparagraph A, B, C, or D, which would stipulate what an acceptable infringement would be. Therefore, all infringement is forbidden. Now, what Congress did a long time ago, if you look here, this is the Federal Firearms Act. They said, you know, where do they get authority? The Constitution reveals that the federal government has no specifically delegated authority to regulate firearms. So where does the federal government authority to regulate firearms come from? Over the last 30 years, laws concerning firearms have been a matter of public policy with no regard to the constitutional element involved. Laws have been written in ever-increasing deceptive manner. Even laws that were clear when originally enacted have been amended over the last 40 years to remove the specificity of the law and render them more vague, make them more flexible interpretations by cooperative judges. Now, at one time, like at 38 law, I'm going to get this up here, okay. You might think that the title Federal Firearms is associated with 18 U.S.C. Chapter 44. Okay, but the Federal Firearms Act of 1938 was originally codified to Title 15. What's Title 15? It is entitled Commerce and Trade. Do you remember the little discussion about creating bag lists where none was before? Well, from 1938 to 1968, the Federal Firearms Act was under Title 15. That was 30 years. Despite the law operating fine for 30 years, someone deemed it no longer proper to have the law contained in Title 15. You want to guess what? That's right. The government jurisdiction limits were far too easy to ascend when the law was within Commerce and Trade title. Now, here's the thing. You cannot stick a gun law in Commerce and Trade. Commerce only means to the flow of goods through the states. Nothing more. It's not to support any firearm laws. What gets me is these people keep putting spins on the Constitution of the United States to make it look different than it really is. They do not have the constitutional authority to pass these laws, and Kavanaugh is going to have a bitch fit when they find out that these laws and these people that are in jail for these laws have to be set free. You know, a long time ago, one of the things that happened after the Civil War, they started passing this Darwin type thing in laws. They no longer went by the Constitution. They were going to go by what the judges said. This guy says, in my constitutional law class at Vanderbilt University, one of the better law schools in the country, we never read the Constitution. We only read what judges said about it. Thus, the judges become a law unto themselves. You understand that? They've changed things around so they don't study the Constitution. They study a judge, what a judge said about a law or about the Constitution, making the judge the law and not the Constitution. They've got to get back to the original intent. That's why I had that thing out here about paper number 22 and 42. That tells you exactly what the heck the commerce was to be. The Commerce Clause was only put in there to keep the flow of goods moving through the states, so there wasn't no animosity because of one state charging more taxes than another one. There's nothing more to it than that. It's original intent. And the best evidence in any court is proof of that. And you have your Federalist Papers and you have your Declaration of Independence. You don't need anything more than that. If these people are not going to follow the Constitution, they got no business being in the Supreme Court or holding down a judge post at any position. That's a problem with this country. There's too much interpretation when there was never supposed to be put a spin on the Constitution. It was meant to be read as is. It's solid. Okay, thanks for watching.